So in her dissent, Anthony, Justice Sotomayor also wrote this. The court gives former President Trump all the immunity he asked for and more. Is that what happened here?
That's right. It's absolutely a roadmap. And I want to be clear about this case, Chris. The right way to challenge elections in our country are through courts of law.
And that happened.
And that's happened 60 plus times. And each one of those times, those courts reaffirmed Joe Biden's victory.
I think 63 out of 64 without even questioning it.
And that should have been the end of it. But what we saw was a president who ignored the facts. He worked around the law and he engaged in a campaign to try to overturn the will of the voters. Now, I want to pick up on something Ken Dilanian just said. And Chuck and I were talking about this beforehand, about any conversations, any actions that happen within the executive branch being taken out of this, about this case. Like, to put some meat on the bones, I'm going to give you an example. In December of 2020, Donald Trump had a conversation with his acting attorney general and his acting deputy attorney general. And Chris, he told them to just say that the election was corrupt. Just say it and let me and the GOP congressman take care of the rest. Now, this was after the Senate confirmed attorney, Bill Barr, had left the department when, you remember, in December of that year, December 7th of 2000, he told the Associated Press that there was not enough of fraud to change the outcome of the election. Fast forward weeks later, Trump is trying to put pressure on his own Justice Department to ignore those facts and to work around the law. That's what's really disturbing to me about this, that those type of conversations can now not be a part of this indictment.
I have been listening to you all day, Chuck. I get the sense that you think this is not the free pass that some people think it is. But tell us your perspective on this ruling.
I'm sorry you've had to listen to me all day, Chris. Nobody should be saddled with that. This is not a good decision for the prosecutors. But I don't think it's the end of the world. It makes sense to me that some core constitutional responsibilities of the president are off limits, are immune. It makes sense to me that purely private conduct of a president is within limits. It's not immune. That makes sense. The difficulty, I think, is that other category, that third bucket, that certain official acts might be immune or not immune, depending on what prosecutors could establish.
What about the instance we just heard from Anthony?
Right. So, I mean, I think that's a good point. I think that makes it tough. I would say in response, and we did talk about this in the hallway, soliciting perjury, right, counseling to someone to lie, doesn't strike me as a core constitutional responsibility of a president. And so the devil is in the details, as Ken Dilanian said. This has to go back to the district court judge, and she has to make detailed findings. And if I were the prosecutor on the case right now, I would be amassing my evidence and my arguments to present to the district court judge why some of these official acts don't deserve immunity. And I think we have to wait and see how that plays out before we can fully assess this opinion.
Jeffrey, we're going to have 2 hours to go into many of the details like that, but I want to read a little more broadly part of Sotomayor's dissent. She says, under the majority's opinion, if a president, quote, orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, immune, immune. Does this ruling change, expand presidential power as we know it?
It does expand presidential power as we know it. And the core of Justice Sotomayor's dissent is that even when you have an unofficial act like ordering the murder of your political rival, you can't use evidence from an official act to prove it. So Justice Sotomayor gives the example of, say, a president says, I'm going to do anything possible to stop my opponent from passing a bill, and then he orders him murdered. You couldn't introduce the overt evidence that he said, I'm murdering him because I want to stop him from passing a bill, because that's an official act. And that's why the core disagreement is Section 3C of the opinion, which has to do with evidence. Can you use the official evidence to prove the unofficial evidence? Justice Barrett came up with a compromise position she would not have created this broad new immunity at all. She would have just asked, does the statute cover the presidential conduct, and does that unnecessarily intrude onto a core executive function? If the court had held that, there would have been far less disagreement between the two sides, because Justice Barrett would allow evidence of those official acts to prove the unofficial acts. So that was the core of the disagreement. Justice Barrett did not join Section 3C of the opinion. And in that sense, the majority unnecessarily embraced a sweepingly broad vision of presidential immunity that exacerbated the division between the majority and the dissent and unnecessarily polarized the country.
So when you have a decision that, as you say, is this broad, how does a court determine what's an official act and what isn't?
Well, that's the crucial question. And what makes this decision so hard to apply is it sends it back to the lower court and punts all those hard questions. It says you've got to disaggregate the various encounters between President Trump and first his vice president, second his attorney general, third the state election officials, fourth his own tweets. And in each case, the lower court has to make a determination about whether that's an official or unofficial act, subject to being reversed by the Supreme Court. And frankly, it's just not obvious in all of those categories how a court could hold, because it's a mix of official and unofficial acts. Take the example of the vice president. He's urging the vice president to commit an act that the vice president himself concluded was unconstitutional, but how is a court to conclude ahead of time whether the conversation itself was an official as opposed to an unofficial act? That's what makes the test so hard to apply. And that's, in practice, what creates this broad new swath of immunity, even when the conduct in question is concededly illegal.
Anthony, you're nodding.
I am nodding. What really bothers me, if I can step back, Chris, about this case, is that it looks like the Supreme Court is just putting their thumb on the scale for this president. And I don't know if you agree with that or not, but, you know, if they really wanted this case to go to trial before this election, like these pretrial motions could have been happening over the last 3 or 4 months. They made the district court put a stay on any type of proceedings. And so that's what bothers me. And I think that's what you are hearing and seeing from some of your Twitter mentions and others. Folks are just, they are frustrated because the Supreme Court doesn't look like they're calling balls and strikes. It looks like that they had a predetermined outcome that they wanted to impose to allow this president to escape criminal accountability. That's what it looks like.
Does Amy Coney Barrett's arguments, because it has a partial concurrence, right? Does it strike you as a more even-handed, fairer potential outcome of this than the one that actually happened?
I think so, yes. I think she takes a more thoughtful, more manageable, more workable position. I want to amend one. I agree with about 93% of what Anthony said.
That's an A.
That's an A.
Yeah. I will take it.
Make it 89%. I don't know that the court is putting its thumb on the scales for Trump. I think they're putting their thumb on the scales for the executive. This court has always believed in a robust executive, right?
I mean, look, if you read the opinion, I'm not going to pretend I've read every word of it, but there is a section where the Chief Justice tries to argue that this is broader. This isn't about this specific chief executive. But do you think that people buy that?
Well, I can't speak for all people, but Democrats get to be president too. And so the holding of this case applies to all presidents, and until and unless it is ever overturned, for all time. And so, yeah, does it help Mr. Trump? Absolutely.
What about the foot dragging? Like, why didn't this court allow the proceedings, the pretrial proceedings, to go on?
So let me so I think that's a really good and important point. Let me disaggregate how long it took from the holding of the case. It took too long. Completely agree with that. And Jack Smith asked back in December that the case be decided by the Supreme Court without going through the appellate courts. And I think that could have happened. But is there anyone really surprised that the Supreme Court would want to weigh in on a decision about presidential immunity? I mean, that's what Supreme Courts do.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.